week. House Bill 24-1294 on mobile homes and mobile home parks. And we're going to be starting the process of gathering feedback for rulemaking to clarify and implement the bill. So as you probably heard, the presentation is going to be recorded. If you would prefer to go off camera for the recording, you're welcome to. We're happy to have folks stay on camera. It's up to you. The recording will be available on the website and shared out after the presentation as well. To ask a question, you can use the chat box if you're joining the meeting today by computer or the Zoom webinar app. You can raise your hand, and you can do this in the computer or the app. Or if you're joining by phone only, you can dial *9, which is the star button, and then the number 9. And I'm going to turn it over to Michelle Goulet, our communications liaison, to talk about interpretation.
Hola. Gracias por venir a esta reunión pública sobre la elaboración de normas propuestas para el programa de supervisión de parques de casas móviles. Yo me llamo Michelle Goulet y estoy encargada con la extensión comunitaria para el programa. Esperamos ofrecer la interpretación simultánea para las reuniones públicas el jueves 20 de junio y el miércoles 26 de junio. Hoy la presentación va a ser solamente en inglés, pero si usted desea quedarse hoy y tiene una pregunta durante la presentación, yo puedo traducirla para Cristina Postolowski, la administradora del programa, quien está presentando hoy. Esta presentación está siendo grabada y la grabación va a estar disponible en el sitio web después de esta presentación. Si desea hacer una pregunta, puede escribirla en la ventana de chat que aparece a la derecha de su pantalla, si está en una computadora o en la aplicación de Zoom de su teléfono móvil. También se puede levantar la mano seleccionando el icono de la mano en la barra de abajo o marcando *9 en el teléfono. Ahora seguimos con la presentación en inglés.
Great, thank you, Michelle. So to briefly summarize for folks who don't speak Spanish and we're curious, we're offering a simultaneous interpretation at the next 2 meetings. So Michelle provided a little guidance on that. And we'll have some materials we'll be sending out in Spanish after this meeting as well. And that is on the slide. Sorry, I didn't advance the slides. So a couple guidelines for today's meeting. As I mentioned, we're talking about a piece of law that was passed by the state legislature and signed into law by the governor. Part of this law went into effect last Tuesday, June 4th, and other parts of this law will be taking effect at the end of this month. The Colorado General Assembly passes the laws. The Department of Local Affairs, of which the Division of Housing and the Mobile Home Park Oversight Program are part, we clarify and implement the laws. We can't change 1294. We can clarify things that are not clear in the bill. We also can't give legal advice. So I may have to decline to answer some questions, or there may be questions that I may need to research and get back to folks about. We're also not going to address questions about individual registrations or complaints on this public meeting. So if you have a question about a mobile home park registration or a complaint, please contact us outside of this meeting at our email address or our toll-free phone number. And Michelle can put that email address and phone number in the chat for everyone as well. Also want to mention at the start of this meeting that there are different types of documents that the Division of Housing can put out to help clarify or implement a law. So we may get feedback at this meeting today that we feel is more appropriate for example, a policy guideline or agency guidance as opposed to a rule. Or your feedback might inform some answers to frequently asked questions that go up on our website. So we're going to listen to all the feedback that folks have today and submit after this meeting. Some of it may be addressed through rulemaking. Some of it may be addressed in other ways. So a little bit on the timeline. I want to give everyone a heads up that we are in the process of adopting a few emergency rules to make sure that our current rules that are in place are consistent with statute. So I have a slide and I'll go over what's going to be in those emergency rules. They have not been adopted by our division director yet. They're with her for review. Those emergency rules, if adopted and if they're adopted and they pass review by the Attorney General, will take effect the date they're adopted. And so we're anticipating that in the next couple of days. We are holding public meetings today through June 26th. And these meetings are the meetings before we formally submit proposed rules to the Colorado Secretary of State. There will also be a comment period after rule language is submitted to the Secretary of State's office. We're anticipating a notice will be published in the Colorado Register of the proposed rulemaking around July 10th, and looking at holding a rulemaking hearing July 30th. We realize this is a pretty quick timeline. We anticipate we may be doing a second round of rulemaking later this year. So there are some things that we are addressing through emergency rules to make sure our rules match statute. There may be some other things that we incorporate in proposed rulemaking during this round, but we're anticipating another round of rulemaking in the fall. One thing that this second round of rulemaking in the fall may also address is the registration fee. We are looking at having to do a fee increase for mobile home park registrations. This is the 5th year of registrations for the program, and we have thankfully not had to increase fees yet. But we'll likely be having that discussion in the fall. Just want to be transparent about that for folks as well. So the emergency rules. Our emergency rules are just going to be ensuring that our current rules reflect what is now in state statute. So there are 2 bills that have provisions that already went into effect that we're making sure our rules comply with. So one of the changes we anticipate in the emergency rules is around the definition of a mobile home park. So the statute no longer uses the word occupied or continuous occupation or operated for the pecuniary benefit of the owners in a definition of a mobile home park. So we'd be removing that language from our rules. A separate bill from the main bill we're going to be talking about today on so the separate bill being 1098 on for-cause evictions, actually updated the notice period for a landlord to enter a mobile home lot from 48 to 72 hours. And this went into effect at the end of April. So we're updating our rules to reflect that. House Bill 1294 on mobile home parks also has a specific time period in it for landlords to provide tenants or former tenants a copy of their payment ledger. There's clarification around homeowners being able to file a complaint if the landlord starts enforcing a previously unenforced rule. And then there's one statutory reference, that 1294 change, that we would be changing in our rules. So I see some questions in the chat from Tom Johnson. So the registration, potential registration fee increase will likely be discussed in the fall, and that's when we would have more information on that. In terms of the update that the Colorado General Assembly made to the amount of time that landlords have to provide notice to homeowners before they enter a lot, I can't speak to that change, but that change, or the reason for that change, but that was a change in state statute. Do note that landlords are not required to provide the 72 hours advance notice if they are posting a notice that is required by law or the lease. So I'm going to start today by going through the changes that took effect on June 4th. So these are the parts of House Bill 1294 that are already in effect. Most of this presentation, if for anyone following along with the bill, is going to go in order of the bill, but there are a couple things that are going to be out of order. And Michelle or Cassie, perhaps you can provide a link to the bill on the Colorado General Assembly website in the chat. So I already touched on the update to the definition of a mobile home park that is in statute. So instead of referencing continuous occupation or pecuniary benefit, the definition of a mobile home park is a parcel of land with 5 or more mobile homes for which the landlord has a rental agreement or is receiving rent payments. The update, there was also an update made to the definition of homeowner. Specifically, homeowner includes residents with rent-to-own contracts under a new section of landlord-tenant law called Part 14, which specifically applies to rent-to-own contracts that are formed on or after June 30th, 2024. The program's current administrative rules consider other individuals with rent-to-own, lease-to-own agreements, homeowners under the Act as well. So I feel like the slide was not where I expected it to be. But I will proceed. Okay. So another piece of the bill that is already into effect is a provision that says a resident may provide a copy of any complaint that they have filed with our program to an eviction court if they're facing an eviction and the complaint is about that eviction. Upon receiving confirmation of the complaint, it says the court shall automatically postpone a hearing for at least 21 days. Our program will be encouraged during that time to review and conduct an assessment of the complaint. Residents are tasked with making reasonable efforts to inform our program of the eviction. Importantly, this new section of law does not apply to evictions under section 38-12-2031F. So that is the section of the Mobile Home Park Act that talks about what some people call substantial violations. So if there is dangerous conduct in the park, property damage, and that's the basis for the eviction, this requirement that a court postpone a hearing does not apply. So this is one area where we are open to feedback on implementation. If folks have any clarification that might be needed on this section or what the process might look like.
Christina, this is Michelle with MHPOP again. Did you see the question in the chat by Tom Johnson about going back to the 72-hour rule, asking to clarify if you can give 10-day or more notice prior to entry?
Thank you for highlighting that, Michelle. So you can give more than 72 hours notice. There is some language, though, in our current rules that clarify you can't give a blanket notice. I reserve the right to enter your lot anytime this year. So I'm happy to share a link to the language in our current rules about advance notice of lot entry. But more than 72 hours is fine, generally speaking. However, you can't do just a blanket notice to enter anytime in the month or anytime in the year. So tree removal, that's also going to be governed in part by our rules that say you can provide advance notice to residents of certain maintenance that you might be doing on their lot, but the notice has to include general dates, times when that's going to be done. Even if the project might take more than one day, you can provide advance notice and say, hey, this is when this is the time frame when we're going to be entering. And I'll grab a link to our program rules that provide more clarification on that for you as well. Great questions in the chat. And I think these are all great questions for us to consider in terms of feedback for potential rulemaking. So just note that I might not necessarily answer a question on this meeting, but we'll take that into consideration. So just reading out some of the questions in the chat for folks who may only be joining us by phone. There's a question from Nathan Westland about whether there's a way to ascertain the legitimacy of a complaint. For example, could someone use the complaint process as a way to delay a legitimate eviction? I think that is certainly something that our program would want to look at in an initial review, and potentially something we could clarify in rulemaking that we will be doing. Encouraged to review, again, without providing any legal advice, I understand that to mean that the program is encouraged to review these complaints, potentially prioritize them, but not strictly required to review every eviction related complaint in the 21-day time frame. Right now, there is not a apologies to folks on the phone. I'm responding to a comment from and questions from Andy in the chat. He also asks, what if the program doesn't review the complaint in time? Also, to whom do you report your quote initial assessment of the complaint? I think that's all great feedback for consideration. The statute does not specifically include a reporting requirement. It just says that we need to conduct an initial assessment. Andy also has a question on 72-hour notice about checking water meters for correct readings. There is language in our current program rules about lot entry for meter readings. So in the interest of making sure that I don't misquote the rules, here is a link to the rules, the current rules themselves. And you'll find lot entry notices are rule 6.6, which starts on page 11. And essentially anywhere that you see 48 hours in these current rules would be where we're updating it to 72 to match the requirement that is now in state statute. So for questions from Samantha Stegner and Tom Johnson on lot entry, I would say please take a look at the current Rule 6.6, which may help answer some of your questions. Jack Regenbogen has a comment that it might be helpful if the assessment of the complaint mentioned in relation to the eviction-related complaints included a determination from our program if the complaint was unrelated or related to an eviction. I think that is a good comment. We'll take that into consideration. Thank you for clarifying, Cassie. You are correct, it's 6.8. The document is very small on my screen right now, so I got the wrong section number. A question from Dan Hunt, is this the only new Colorado statute affecting mobile home parks? No, this is, so House Bill 24-1294 is specifically about mobile homes and mobile home parks. But the other bill that I mentioned on for-cause eviction, House Bill 24-1098, also has some provisions that will affect mobile home parks, specifically if the landlord owns homes and is renting out homes to residential tenants. There are changes in 1098 related to terminating a renter's tenancy. But that does not include any changes specific to the reasons landlord can terminate a homeowner's tenancy. There is also another bill that was signed into law on mobile home titles. It is a mobile home title task force and study bill. The Division of Housing will be setting up a task force to receive input on titling for mobile homes and the titling process. I'm sure others on this call who are more involved in the legislative process can name others. David, Jack, Tawny, feel free to put others you might want to let Dan Hunt know about in the chat, but those are three that immediately come to mind for me. So I'll go ahead and move on to the next slide. Please, if you have thoughts after the meeting on anything we're covering today, feedback, we'll provide information at the end of the call on how to get that feedback to us. There is a section now in the Mobile Home Park Act that specifies a landlord cannot charge a resident any fee, penalty, or other cost for refusing to sign a new lease or residing under a month-to-month or other periodic tenancy. So we've seen what we've seen called month-to-month premiums, for example. Those are not permitted, and the statute is clear that those are not permitted under the Act. There were changes made to the water that a landlord has to provide if there is a water service disruption in the park. So one clarification that is hopefully helpful to landlords is that a landlord is not in violation of the Mobile Home Park Act if there is a third-party water provider that shuts off water to the park for a reason unrelated to anything the landlord's done or hasn't done. If a landlord fails to maintain or repair water lines, there's a provision in current law that says a landlord must provide and pay for potable water, water that's safe to drink. The bill, which is now law, clarifies that potable water that's sufficient for drinking and cooking has to be provided within 12 hours of the service disruption, and potable water that's sufficient for bathing and other essential hygiene for the household has to be provided within 72 hours. Question I have for feedback is whether it would be helpful to clarify how much water is reasonably sufficient for these purposes. See a question from Tom in the chat. What is considered reasonable occupancy of a 3-bedroom house? I would likely defer to the local jurisdiction if they have any occupancy restrictions or not. Question from Samantha. Has any clarity been made or is it already in place on what the PSI level is that water can drop to before a landlord has to provide notice? So there is a PSI level that triggers a boil order from the Colorado Department of Public Health and Environment. It's my understanding that below 20 PSI triggers a boil advisory via CDPHE. However, CDPHE for boil advisory, there's also a certain number of homes that have to be impacted, or a certain amount of the system. So it's my understanding that it's 100 homes or half of the distribution system that also factor into whether a boil advisory is issued. So that is some information from CDPHE on that. So question from Tom, if there's not an occupancy limit, would he need to supply water for 12 to 14 members of a household? The statute does say all members of the household, but that's potentially something we can look at clarifying through rulemaking if there is a local limit on occupancy and the household is above that limit. So we'll take that into consideration. comment from Jeff Leake in the chat that clarification is what is reasonably sufficient for water is critically important.
Christina, this is Michelle from MHPOP again. I see Anna Mae Smolinski has her hand raised.
Okay, feel free to open up the line to her.
Hi, can you tell me if there's a specific amount of water per person that a landlord has to provide per household, like, it says for bathing and other essential hygiene. So is that like for sponge baths or like full showers? Like, what is the, you know?
That is a great question, Anna Mae. That is not something that is specified in the Mobile Home Park Act right now. The Colorado Department of Public Health and Environment, or CDPHE, I've heard speak internally of what they generally consider sufficient for different purposes. But it sounds like it would be helpful to have more guidance on this for landlords and homeowners.
Thank you.
So a little bit about boil water advisories. And this is a new part of the landlord responsibilities. So the landlord must provide potable water if the park or residence lot is subject to a boil advisory, specifically due to maintenance or repairs being done by the landlord. The same time periods apply if there's a boil advisory as if there's a service disruption. So water for drinking and cooking within 12 hours, water for bathing and essential hygiene within 72 hours. The Mobile Home Park Act now says landlord must post a notice on each lot in English and Spanish of each boil advisory as soon as possible or no later than 24 hours. For mobile home parks that are regulated public water systems through the Colorado Department of Public Health and Environment, those communities will have a water operator. The Colorado Department of Public Health and Environment typically communicates with the water operator, and the water operator will get notice of any boil advisories that the Department of Public Health and Environment are issuing for the park, and there's a notice requirement that goes with that through CDPHE as well. So looking to see if any clarification is needed on this section about whether all lots need the boil to get the boil advisory or only those impacted, or other areas where clarification might be needed. And I'll just point out on this slide the requirement that the notice of the advisor be provided in English and Spanish. You're going to see a lot of language access requirements in the Mobile Home Park Act and in this presentation as well. So just be aware that's a big part of this new bill. The division does plan on posting some resources on our website for landlords to go to if they need to get a document translated or need to hire an interpreter. There's a question in the chat: is a boil advisory triggered every time water pressure is below 20 psi? For example, they turn water off for a plumbing repair that lasts 2 hours. The Colorado Department of Public Health and Environment would be the best agency to answer that question. That's something that I can look into and follow up on. It's my understanding that it is depends on how many homes are affected, but I'm not aware whether it matters how long the pressure drops for. So question in the chat: what's the effective date to begin providing notices in English and Spanish? These notices of boil advisories, this is currently required under state law. Other communications are not required to be in both languages or other languages until June 30th. And so we have the presentation separated out. So the stuff I'm going over now is stuff that's already in effect. There's some clarification in the section of the Act on the landlord's responsibility to maintain park premises. So the bill clarified that maintaining roads and other pavement includes maintaining sidewalks in a passable, safe condition, and that the landlord's responsible for snow removal on pedestrian sidewalks and roadways that provide access to public notice areas, mailboxes, and other public buildings. We are taking feedback in this rulemaking on whether we should clarify that snow removal is not required in winter in seasonal parks. So these would be properties that are mobile home parks, but do not have any residents between a certain period of time during the year. See great questions and comments in the chat for feedback. Anna May has asked, does this requirement include driveways? Tom has commented on what amount of snow triggers a plow or clearing. We will take that into consideration for the rulemaking. There are changes that have gone into effect related to the types of park rules. So these are the rules and regulations that the landlord establishes for the community. So the types of park rules that are considered enforceable under the Act. These changes in House Bill 24-1294 specifically apply to park rules that impose restrictions or requirements on a homeowner's mobile home, accessory building, or structure. The statute clarifies some park rules that are presumed unreasonable and unenforceable. This is a rebuttable presumption, meaning that the landlord can provide evidence that the rule is enforceable under the Act. And this section also authorizes the division to promulgate rules specifying that certain park rules that affect tenant-owned homes, accessory buildings, or structures that are strictly necessary and are not strictly necessary and are unenforceable, or are strictly necessary and are enforceable. So for example, we see complaints about some of the same types of rules. And we're looking for feedback on whether certain types of rules under the statute should be presumed to be okay for the landlord to have and enforce, or not okay for the landlord to have and enforce. So some examples we're looking at are park rules prohibiting window AC units, or putting restrictions on the type of window coverings residents can have. Those might be presumed unenforceable, whereas rules that pertain to the cleanliness of the exterior of the home, or prohibit, for example, window coverings or other postings on the home with obscenities, might be presumed enforceable. I see some more great comments in the chat stating that a rule defining pavement is necessary, particularly to clarify driveways and personal walkways onto lots, and whether it's the homeowner or the landlord responsible for shoveling those areas. Question about whether the statute requires every sidewalk from every home site to the community to be cleared, or just the sidewalks around the common areas, or around the sidewalks to the home sites. And then a comment: in the event a sidewalk needing snow removal requires access to a lot, how does the landlord gain sidewalk access without 72-hour notice? So all good feedback on the snow removal section of the law. Comment in the chat that unfortunately some parks have rules that violate many statutes, and complaints have been put to the program that have not been resolved yet. Can parks be held responsible for just having such violations in their written rules versus just when the park acts on penalizing a resident for such rules? A great question and piece of feedback. Another comment: more long-term, perhaps beyond this rulemaking timeline, it might be beneficial to have a working group that looks at developing a template for model park rules. Also a great suggestion. Okay, so more on park rules, specifically as it relates to a landlord terminating a homeowner's tenancy. So as of last Tuesday, if the landlord's issuing a tenancy termination notice based on a park rule violation, the termination notice must include a statement that specifically sets forth the basis for enforceability of the rule under the section of the Act on Park Rules and Regulations, which is 214, and the section of the Act on lawful reasons to terminate a homeowner's tenancy. The termination has to also include language on the specific purpose of the rule, and how the rule is reasonably related to the stated purpose. A general statement in the termination notice, which might also be called a notice to cure or quit, that the rule promotes safety or welfare is no longer sufficient. And so one piece we're wondering whether we need to clarify is, do we need to clarify the notice must describe how the rule is, quote, necessary to prevent material damage to real or personal property or to the health or safety of one or more individuals, which is the language in 2031C. Stacy, question in the chat, can park rules and regulations for communities be made to go before the program, for review, before they can be distributed? Unfortunately, the program does not currently have the capacity to do that, or to provide legal advice. Perhaps down the road, something like a task force could help with providing guidance on the types of rules and regulations that are essentially safe to adopt or compliant with the Act. We will share a recording of the meeting and we will post it on the website. Okay, so another piece of the bill that is now in effect is clarifying what the management or landlord can require in terms of assessing the financial ability of a prospective home buyer to afford to live in the park. So this is often part of the tenancy application process. So the Mobile Home Park Act now says that the management can require a prospective home buyer have a monthly income of at least 200% of the seller of the home's current monthly lot rent for 1 month, or other cash assets of at least 200% of the seller's current monthly lot rent for 6 months. So essentially, a landlord can require, but is not, a landlord may, but is not required to require a homeowner to make double the current monthly lot rent, or have assets double 6 months worth of rent in order to prove their tenancy in the park. The question on whether it's clear from the statute or clarification is needed that this also means the management can't require buyers to demonstrate assets or income above these amounts. So statute says 200%. That means the landlord can't require 300%. Question on if there's a limit on what a landlord can charge for lot rent for incoming new residents. There is not a dollar limit. I believe there may be some provisions around parity in terms of how they're charging people across the park. But I have to confirm that. Perhaps one of the attorneys on the call might know. But there's not a specific dollar limit or a requirement that the lot rent be based on a fair market value. And Jack, thanks for the feedback on the clarification and tenancy termination notices as well. Okay, some changes to the park sale law. There is a clarification that's now in the Act that the seller of a mobile home park is not required to provide additional sale notices if they are only considering an offer to purchase the park from a group of homeowners. So if the landlord is strictly negotiating with a group of homeowners and the terms are changing, the landlord doesn't have to give more notices to those homeowners who are already part of the conversation. However, if there's a new triggering event involving a different party, a new notice would be required. There is a new section of the Dispute Resolution and Enforcement Program Act, which went into effect last Tuesday. So this section is 1105.5, and it has to do with mobile home parks where there is a potential sale and also pending complaints, unpaid penalties, or incomplete remedial actions. Currently with the mobile home park oversight program. So as of last week, as a prior condition of a sale or change in control of a mobile home park, the seller is required to provide all documents related to any MHPOP complaints against the seller to a prospective buyer as part of the due diligence process. Seller is also required to provide all documents related to any complaints against the seller where a notice of violation or final agency order were issued by the mobile home park oversight program, but the seller has not finished complying. And this again is the documents need to be provided to a prospective buyer as part of the due diligence process. And the seller has to pay any and all outstanding penalties ordered by the division in a final agency order and submit an affidavit of compliance to the division. The division put together a template letter this week for us to send sellers about these new requirements, and a template letter that sellers can send buyers about these new requirements. We anticipate that sellers will reach out to the mobile home park oversight program for the documents that they need to provide prospective buyers related to complaints, and that the division will be providing those to sellers. We also anticipate that a seller may know about some, but not all pending complaints, at least based on our current complaint process, where we communicate with the complainant first and collect additional information before contacting the respondent. So I anticipate there'll be some questions about this process or the timelines. So we're open to getting feedback on that. Here's some more of what is in the new section 1105.5. So if a park is for sale and there is a pending complaint with the mobile home park oversight program, the Division of Housing can order, or a prospective buyer can request, that the seller of the park put money in an escrow account that is sufficient to cover remediation costs or an estimated penalty that could be assessed by the division. So again, this is for a complaint that has been made to the program, but where a decision has not been made or the complaint has not been resolved yet. The seller is entitled to the return of the money if then no violation is found. So open to getting feedback on this section and how it should be implemented as well. Finally, there's some language in new section 1105.5 on what happens if a park is for sale and there are outstanding remedial actions. So if the Division of Housing has ordered remedial actions in a final agency order before a park is sold, the landlord has to complete all actions before the sale is completed and submit an affidavit of compliance to the division. Or the landlord and prospective buyer have to put together a joint remediation plan to complete the actions within a year and submit that to the division. Now, there's language in the statute that is not on this slide that says the division does not necessarily have to accept the remediation plan. But that is one option for resolving the pending or the outstanding remedial actions. The statute also says that the division can add a landlord successor in interest as a party to a complaint. So if a park is sold, the new owner may be a respondent in a complaint that is still open or pending, that was previously filed or made against the seller. See a question from Luis in the chat about the financial ability to pay. What if a homeowner has a mortgage payment along with the lot rent? Does an applicant only have to show proof of 200% of their monthly income for lot rent, but not for the mortgage on the mobile home? The language in the statute is specific to lot rent. Happy to look at that closer though in our rulemaking or providing future guidance on that. Okay, so those are highlights of the sections of House Bill 24-1294 that have gone into effect. I think we can start going through a couple of the changes that will take effect June 30th. If folks have feedback, please continue to put it in the chat, raise hands. We'll see how far we can get with the rest of the content. If not, we will pick up at our next meeting where we leave off today. So these are changes in House Bill 1294 that have not taken effect yet, but will go into effect on June 30th. So there is a new section of state law on rent-to-own agreements in mobile home parks. It is going to be Part 14 of the landlord-tenant laws. This new Part 14 applies specifically to rent-to-own contracts formed on or after June 30th. This section of the law is going to be enforced through a private right of action in civil court or through complaints to the Attorney General's office or investigations by the Attorney General's office. So this Part 14 will not be enforced through the Mobile Home Park Oversight Program. We do anticipate that we will be answering questions, providing education resources or referrals to individuals who contact our program about rent-to-own agreements. But we don't have jurisdiction over complaints about this new section of the law. So I'm not going, in the interest of time, not going into any further detail. But if you are a landlord who has rent-to-own or lease-to-own agreements, be aware of this new section going into effect later this month. We are in this rulemaking considering a couple of updates to the rules around what's required with the mobile home park registration, the annual registration information. So for example, I mentioned earlier, the definition of a mobile home park no longer uses the word occupied. Our registration form and the mobile home address list that goes with the form ask for information on occupied versus vacant homes. So we're considering instead updating that to match current statute. So asking about what lots the landlord has rental agreements for, receives rent payments for from independent homeowners or from renters of a home, and which lots, mobile home lots don't have a rental agreement or rent is not being paid on at all. One piece of the Part 14 on rent-to-own contracts that does fall under the mobile home park oversight program is a requirement for landlords to disclose rent-to-own agreements they hold as part of the annual park registration. We're anticipating adding that as a column on the mobile home address list. And have a question about whether to clarify this only applies to rent-to-own contracts on or formed on or after June 30th, or if it applies to all rent-to-own contracts in terms of providing information as part of the registration process. See a question or a comment in the chat, parks are carrying over registration fees to the tenants. So Cassie responded in the chat to that. Landlords may, but are not required to, pass on up to half of the registration fee to tenant homeowners. They do need to provide 60 days advance notice to pass on the fee, and they can only pass on half of the fee, which currently half of the fee is $12 a year. What if the home is under a sales contract with the mobile home park? I would potentially look at the definition of rent-to-own contracts in what will be the new Part 14 in the bill to see if the particular sales contract you're thinking of would fit under that rent-to-own definition or umbrella or not. A comment that mobile homes should not be allowed to, or mobile home parks should not be allowed to sell the homes. Landlords are permitted to own homes in mobile home parks and to sell those homes to prospective tenants. Landlords may be required to register as a seller with the Division of Housing, in addition to registering as a landlord. And there is it's sort of our sister program, the Building Codes and Standards program at the Division of Housing regulates registered sellers. A comment about there not being a limit on increases in lot rent. That is correct. There's currently no limit in state law on the amount a landlord can increase lot rent. Comment that landlords should be required to have a real estate license. They may be required to have a real estate license as well if they are selling homes. It has to do with whether they're also negotiating the lease for those homes or not. That's something that we can look at sending more information out in an FAQ. through our newsletter. When a landlord who's selling homes might have to be registered with the Division of Housing, have a real estate license with DORA, both or neither, because it depends on what they're doing in each transaction. A change taking effect June 30th related to condemnation of a mobile home park. So Bill 24-1294 clarifies that if a park is condemned for reasons that are the responsibility of the park owner and mobile homes are going to be displaced, impacted homeowner or homeowners can demand compensation, similar to if a landlord is closing part or all of the park to mobile homes through a change in use. While there is not a limit on the amount that a landlord can increase rent, there will be some additional language in state law that prohibits landlords with certain types of violations or non-compliance from increasing rent. So rent increases and notices of rent increases are prohibited if a mobile home park has not fully complied with any final federal, state, or local administrative or judicial order, or the park has been found by the Division of Housing or a court to have violated the section of the Mobile Home Park Act on landlords' responsibilities to maintain the mobile home park within the 12 months before the division or the court's order. This provision about violations found by the division or a court does not apply if parties settle before a final agency or court order, final agency order or court order is entered into. So we are open to feedback on whether any clarification is needed on these provisions or around implementation of these provisions. The division does currently have a list posted on our website of mobile home parks that are currently prohibited from increasing rent based on limitations that are already in the Mobile Home Park Act. So if a landlord does not have an active registration with the program or has an unpaid penalty owed to the program, for example, that landlord is not permitted to increase rent. And a list of parks that fall under that prohibition is available on the division's website. Question in the chat or comment that notices should be allowed in advance of the 12 months. The notices can be, this provision only applies to new notices of rent increases, but it looks at any violations that occurred within the last 12 months, if that makes sense. But I think some clarification might be needed on the second bullet here. Comment, if complaints to the program are delayed by years, parks can still increase rents when an active violation, but haven't been formally pinged by MHPOP. What is MHPOP doing to speed processing of complaints? So thank you for the feedback. We have set some goals internally around processing of complaints and clearing our old complaint backlog. We're also currently fully staffed on the complaint side of our program. So we are hoping to address concerns about complaint processing times moving forward. Community meetings. So this is the start of the section of the presentation on language accessibility. I would say probably in the interest of time today, it may make sense to discuss the couple of slides we have on language accessibility at the next meeting. Because we've got several of them and they are important. So we will pick up at with the section on community meetings at our next rulemaking discussion. And then we'll probably go back around to the beginning of the presentation. Again, these presentations will be recorded if you miss one. And want to make sure everybody has information on submitting written feedback to us. So please submit written feedback that you have, thoughts after this conversation today or down the road to our program email address, which is MHPOP as in Mobile Home Park Oversight Program @state.co.us. Please include MHPOP rulemaking or rulemaking in the subject line, all one word. That will help us distinguish emails that are comments on the rulemaking versus questions or comments related to registration or complaints. You can also mail feedback to us at Division of Housing. Please put in attention MHPOP rulemaking on anything that you mail. Our address is 1313 Sherman Street, number 320, Denver, Colorado, 80203. I've provided my contact information and the contact information for our communications liaison, Michelle, on the slide as well. And we will go ahead and post these slides online before the next meeting to give folks a little bit more time to prepare their thoughts. I also hope to send out some red line draft rule language before the end of the month, before we formally notice, to give some people time for feedback. Thank you to everybody for your participation and comment today. Really appreciate your input, and I know this was put together on short notice. So again, thank you to everyone who joined today. In terms of how quickly resources for translation of documents might be on our website, I'm thinking we can likely, Michelle and I can likely get some companies that provide those services next week. Well, thank you, everyone. I'm going to go ahead and turn video and audio off, and we're just going to make sure that we've got our recording and we've got, we save a copy of the chat before we close out the meeting, but folks are welcome to leave the meeting at this time. Thank you.